every person is equal before the law. Now, the idea of rule of law, of course, goes back, for a while. But what we're seeing now is that the expectation and reality are quite different in terms of everyone being equal under the law. Because, for example, different people have different ability to pay lawyers. That is not equal. So if we're looking at something where every person is equal before the law, then would the minister then, for example, consider access to law should just be free for everyone, in which case everyone then would be equal and have free access to that. And in that sense, I would agree that yes, everyone is equal under the law.
Thanks, Mr. Chair, and my questions are also in the section relating to the rule of law, but from a slightly different angle. So every person is equal before the law, and we traversed the meaning of the word equal or equality in the Treaty Principles Bill discussion, but I want to bring it back today because obviously there are different ways to interpret the word equal. There is formal equality, which is the concept that everybody gets the same thing. And then there is substantive equality, which is the recognition that everybody doesn't start out on the same playing field, and that because of that, some people need more than others to bring everybody up to the same level. So what does the minister mean when he says equal before the law? There's probably more interpretations to the word equal than those two. Dr. Marilyn Waring had a really good explanation behind those two concepts, but what do you mean by equal? Because there's lots of different ways to interpret that one word. And I think my colleague, Dr. Zhunan, touched on some really good examples of inequality before the law, because this sentence, every person is equal before the law, is simply not true in our courts and the way that our law is applied. So Dr. Zhunan made some really good points around how much access you have to money can sometimes determine the way in which you are impacted by the law, which is a really great point. It made me think about even things like the removal of Section 27 reports, which allow for the courts and the judiciary to have a more fulsome understanding of who a person is, where they've come from, what their challenges are in terms of their health, their upbringings, etc., etc. But if you can't afford to commission your own cultural report now, you don't have the same standing in front of the courts. Unlike if you have money, you're able to access or commission those reports, and the judiciary will have a better understanding of who you are and will be more forgiving and more compassionate towards your circumstances, and will likely give you a more flexible or compassionate sentence because you have been able to pay for that report. So everyone isn't equal under the law. It depends on how much money you have access to. So can you address those discrepancies? But let's also talk about race when it comes to everybody coming before the law, because here's another fact for you, Minister. Māori are 11 times more likely to be prosecuted for the same offence as non-Māori. So I'd love if the minister could explain where that discrepancy comes from, because clearly if you have a brown face and you appear before a judge or a lawyer, you are not going to be treated in the same way as somebody who appears before a judge with a white face. And that might be uncomfortable to hear, but that is the truth, and it has been traversed by many courts, many judges and many lawyers who point out the institutional racism that exists within our criminal justice system. So in terms of the rule of law, I'd love for the minister to answer some of those questions, but it's the kind of obvious glaring omission in this entire section around the rule of law is the complete absence of tikanga Māori. The original law of this land, by the way, there is no provisions whatsoever that recognises tikanga Māori, despite the fact that many rulings in the court have considered and applied tikanga Māori. And if we want to be specific about what that is the original law of this land and the way that decisions and justice was fulfilled for the Indigenous people who are here in this country first. And in this modern day, in 2025, It's not extraordinary or spectacular to see tikanga Māori to be written into and considered into a judgment. So why is it that in this piece of legislation that attempts to be a modern piece of legislation completely ignores the very hard work of people like Justice Joe Williams, who have incorporated tikanga into their rulings? This completely erases that and makes no mention whatsoever of tikanga Māori, which is why I've drafted an amendment paper to amend this part to include the importance of maintaining consistency with the following aspects of the rule of law, noting that nothing below precludes tikanga Māori being recognised as the original law of this land. So I'd love it if the Minister could start there, but I've got more questions around Te Tiriti and tikanga Māori to follow.
Mr. Chair. Thank you, Mr. Chair, and thank you, members, for your questions and comments. Lawrence Yunnan and Tamitha Paul both raised a series of issues around the practical ability to access the law in their critique of the rule of law section, particularly the idea that every person is equal before the law. There are extensive political debates about equality of opportunity and equality of outcome. There are policies, for example, legal aid that assist people to access the law. There has been in the past funding for Section 27 reports. Those are all interesting and important areas of policy debate, but they actually don't concern us here. The statement every person is equal before the law simply means that if there is adjudication of a matter, then people should not be treated differently based on their identity in the same circumstances. Very happy to have a debate about access to law and legal aid and so on in another format, but it's not actually relevant to this part.